Very warm welcome to all present here. The GST Tribunal is slated to commence its operations in across various states and locations, with different dates being mentioned for each of them. So this is effectively about close to 8 years post the introduction, or 9 years of introduction of GST, and with people waiting for filing their appeals, and the government's push has consistently been to ensure that online filing is being done, and that's what the GST tribunal's mandates have been, to ensure that the whole workflow is regulated through online. Comes with its own set of legal procedures, practical challenges, and because of offline and online combinations in prior locations, prior areas like adjudication or appeals, how the transitions have to happen. So these are all areas which have to be looked into. So in this context, we have this session where we have the panel of legal experts who are specialized on the tribunal and the court functioning process, and who are experts in this area, to share their experiences as well as the thoughts on the GST process. So I hope this session will be useful to all, and any questions could be reserved at the end of the sessions, and people can shoot their questions at the end. Once again, warm welcome to all. Thank you.
So thank you all again for this. Again, I should thank the organization for giving me an opportunity to speak on this topic, which is hot and happening topic, I can say. So this, as TRS was also laying the groundwork, so almost 9 years into the GST era, we in fact have a GST 2.0 which has come. Even as early as September 2025, we have even GST 2.0 system which has come. So anyway, even after such a long time in GST, now we are finding that the appellate mechanism was not fully complete. So in the sense that normally in earlier legacy laws like excise or service tax, you find that in indirect tax laws and to almost all tax laws for that matter, there's a four-tiered appellate structure. So one, you have the appeal within the department. So which we normally say in income tax as commissioner appeal, CIT appeal, so on and so forth. In excise service tax, CST or CC appeals used to be there. So that is the first authority, which is more of a appeal within the department. That particular appeal, if you see, I mean, it can to some extent only render justice, I can say, because we should all accept the reality also that even though they are the officers mean to be a little bit what I can say impartial, or we can say unbiased to both the things, but in reality we find that even at the first appellate level there is a little bit of due to various practical reasons a tilt towards the departmental side is there. So this is a reality. But so therefore that's the first appellate structure. The second is the tribunal. The third and fourth are, needless to say, High Court and Supreme Court. So therefore, in GST era, we have seen that the first appellate authority has been dispensing justice in appeals for quite some time now. It has been doing it for more than 4 years plus. Whereas we are seeing that the second appellate authority, which is the tribunal, it is not yet fully functional, and now it is in the process of getting functional. This tribunal occupies a very, very unique place. Why? Because this tribunal is the final fact-finding authority. One, as I was mentioning earlier, the concept of an inherent bias towards the department, that gets to a large extent corrected in this particular GSTAT, because we have members who are judicial members who are coming in, members from the department, technical members who are coming in. So therefore, we see that the dispensation of justice is a little bit more even-handed, we can say. So therefore, tribunal occupies a the second appellate authority occupies a very unique place in this entire appeal dispensation mechanism. Now, the finer aspects of tribunal is that the few things we need to note as all professionals sitting here, tax heads, members from industry, is that this tribunal is the final fact-finding authority. Therefore, any questions of fact, you want to bring it on record. We always used to say, even within our office or wherever I go and address, I used to say, you should put in maximum facts. Your whatever facts are there in your case, the maximum facts have to be presented at the lowest level. That is the rule. So you cannot keep on adding new and new facts at every further appellate forum. That is not possible. So the maximum facts have to be introduced at the lowest level. Otherwise, what happens at every appellate stage you climb, there will be a rebuttal from the department. No, this is an additional evidence that has been brought in. Why should you allow it? So you should go on to justify that, no, I was prevented by sufficient cause from introducing this fact at an earlier level. For example, let's say a particular certificate is there. You have not produced it at an earlier level. You want to produce it now. You'll have to justify it. Why were you prevented from producing this earlier? So therefore, you can't keep adding evidence at every point of time. It becomes tougher and tougher. So therefore, you will see that at the first appellate authority, little bit of relaxation is given. At the tribunal, it becomes a little harder. We have separate rules. We'll see. Today, Rule 45 and Rule 112 of the Rule 45 of the procedure rules are there. Rule 112 of the CGST rules are there. There are given situations where you can introduce this evidence. But the point is, at the tribunal, at least you can introduce that evidence, new evidence, additional evidence. At the High Court, questions are only that of law. Questions of law only are taken up at the High Court. And at the Supreme Court, substantial question of law certified as fit by the High Court are only taken up. Therefore, the higher you go, more than the tribunal, the questions of fact cannot be introduced or new evidence cannot be introduced. The debate or the arguments will only be on questions of law. Therefore, the tribunal is the final fact-finding authority. This is the unique place of the tribunal. The second unique aspect of the tribunal is that the tribunal is also a quasi-judicial body. This is a very important point. Because after, I used to say after listening to Ramayana, you should not ask who Rama and Sita are. So therefore, after this session, what are the aspects of tribunal? Probably it should be there in our minds really etched really well. So therefore, tribunal, the first thing is that unique aspect is that it is the final fact-finding authority. The second aspect is that it is a quasi-judicial body. Quasi-judicial body which has the power to regulate its own procedure. Please note, ladies and gentlemen, that the tribunal is not bound by the Code of Civil Procedure 1908. It is not bound by it. 1908 Act does not bind the tribunal. Tribunal has its own procedure rules. That is why we are seeing today, my learned colleagues will also talk about this procedure rules in subsequent parts of the session. That separate procedure rules are there for the tribunal. The Code of Civil Procedure does not apply. 1908 Act does not apply unless the rules itself or the act itself provides so. For example, in the case of issuance of summons, enforcing the attendance of persons, etc., the act itself says that the code will apply. Code of 1908 Civil Procedure Code will apply. So therefore, where it is mentioned, it will apply. Otherwise, it will not. Tribunal has the power to regulate its own procedure. This is another important aspect. So it's a quasi-judicial body with enough powers to regulate its own procedure. Inherent powers are there. But please note, ladies and gentlemen, inherent powers are there, but the powers are not unlimited. The tribunals are still governed by the Act and the rules, the Parent Act and the Parent Rules. Even though inherent powers are there, but please understand the distinction. Inherent powers does not mean unlimited powers. So therefore, tribunals are still bound by the Act and they are also bound by the Parent Rules. But within that framework, inherent powers are there to regulate its own procedure and to do whatever it is to meet the ends of justice. This is what the procedure rule, if you look at Rule 13, it will say it can, power to relax procedure is there. If you see the Act also, Section 112, so on and so forth, it has the power to pass orders to meet the ends of justice. You will find this one. So therefore, it has the powers. Inherent powers are there, but they are not unlimited. So this is what we'll have to really keep it in mind. So therefore, these are the unique features of the tribunal. Now, before going into the finer aspect, I have very limited time today because 4 parts of the session are there. So therefore, I will try to restrict myself to the salient aspects of the appellate process. And I will focus on tribunal. I've told you the unique aspects of the tribunal. Now, the other thing that we have to remember is, I would ask the participants here to ask themselves a question. All of you are in the process of already filed some appeals or in the process of filing appeals, especially second appeals before the GSTAT. So I would want you to ask yourself a particular question. What is the nature of the appeal remedy? Is the appeal remedy in the nature of a right, or is it in the nature of a benefit, or is it in the nature of a privilege? This distinction is very, very important. For want of time, I'll give the answer myself. It has been held. Please note, I'm not discussing any thesis. Sir, what are you discussing? Something theoretical. Please note, this is not the case. When you argue before the tribunal, there are many situations where this particular foundational principle will be put to test. I will tell you the decision of the Supreme Court in the case of GlaxoSmithKline, where the Supreme Court has categorically held that the right of appeal is, the remedy of appeal is a nature of a right. Same is the case with ITC, the same debate is there. Of course, we have varying decisions in the context of Sutherland Global and so on and so forth. There are varying decisions there. But leave aside ITC for the time being, coming to appeal at least without diverging the subject. The nature of the appellate remedy is in the nature of a right. It's not a benefit, it's not a privilege. Therefore, it's a very important thing that you have to understand. And what sort of a right it is? The next question. Is it a fundamental right enshrined in Article 19, Subarticle 2 or 20 or 21? Is it a fundamental right? Or is it a constitutional right like the right to property, Article 300A? Or is it a statutory right? Is the next question. Again, I'm not going theoretical for want of time. Again, there are decisions which say that the right to appeal is neither a fundamental right nor a constitutional right. Rather, it is a statutory right. This is very important. Sir, why are you talking theoretically? No. Please understand, if it is a statutory right, the remedy is fettered by the conditions put by the statute or conditions imposed by the statute. It is subject to that. You cannot claim it as an absolute right by itself. It is subject to conditions. For example, we will see in the context of pre-deposit, the same decision which I mentioned, GlaxoSmithKline, in the context of limitation rather, the same decision of GlaxoSmithKline will be very important for you. There are contrary decisions, either ways are there. But if you see, it will mention that in this particular decision of the Supreme Court in various paragraphs, it has been held time and again that even the high courts or Supreme Courts do not have the power to condone beyond what is given in the Act. Therefore, the Act has provided for a 3 months filing period plus a 3-month condemnation period in case of tribunal appeal. Even the high courts under rich jurisdiction or the Supreme Court for that matter cannot come into this particular cannot extend beyond this particular 3 plus 3 months. Therefore, it is a statutory right, and the conditions, you cannot say, no, appeal is my statutory right. I can enforce this right even after 10 months. I can enforce this right even after 2 years. Not possible. It will become incrementally tougher. Please note, when we defend your cases again, there are again decisions both ways. We will try to argue the best of you this one. But what I'm trying to say is, you cannot claim it as an absolute right is what I'm trying to say. Therefore, the remedy of appeal is a right, first point, and it is a statutory right, and it is not an absolute right by itself. And once you fulfill those conditions, it becomes a vested right. It cannot be taken away. This is also very critical. Once you fulfill the conditions of the statute, no, sir, I've filed the appeal within the correct 3 months time plus 3 months condemnation. I have also made the reasonable cost for that one. I have filed it correctly. I've filed the correct form. There's no defects. I've paid the pre-deposit. I've paid the fees. You fulfill 1, 2, 3, 4, 10 conditions. What is given in the statute, you fulfill that. Then the right becomes a vested right with you. It cannot be taken away simply. You are protected by Article 14 of the Constitution. The appellate authorities are bound to give reasoned orders. They cannot give summary orders and dismiss your case. So once you get that right, it becomes a vested right, becomes a strong right, and your matter cannot be dismissed unless you are heard fully. Principles of natural justice, you have to be given that one. The order should be a very recent order. Due process should be followed. Procedure rules should be followed. So once you fulfill all those conditions, it becomes a vested right, and therefore you are entitled to the protection of the Constitution once you fulfill the conditions. Therefore, what is the very nature of the appellate remedy is something that you have to think about it. And this plays a huge role when we talk about many of the aspects of the appellate process. Now, without going too much into the basics, going to the important aspects. Fine, sir. Now you tell me about the tribunal appeal. Please note, normally this is second appeal. We have a 4-stage appeal process. Normally this is second appeal, but we see that there are some exceptions also. Sometimes it can be a 3-tiered appeal structure also. Sometimes it can be even a 2-tiered. I'm not going to the complexities of this one, but normally it's a 4-tiered appellate process, and the tribunal appeal is the second appeal in a normal situation. Now, first of all, we need to know what are the benches of the tribunal. Now you are going to file an appeal. Which bench of the tribunal are you going to file an appeal is the first question you have to answer. The question of jurisdiction is quite important. You cannot miss jurisdiction. Again, I'm not making a political point, but nowadays we have a lot of we have a lot of JPs, right? Even the CJP is now making trend in the Twitter and all. I heard. So just like what is that? The CJP. I would ask all the participants here to remember these 3 words or these 3 letters when you talk about tribunal appeal. I will say it is LJP. LJP. L for limitation, J for jurisdiction, and P for pre-deposit, P also for procedure. So LJP, have you satisfied, is what you have to really think of. It may be a very crude way of remembering, but I thought it is relevant for the day, especially with what is going on in social media. So LJP is a proper way to remember this second appeal. So L is limitation, J is jurisdiction. So coming to the jurisdiction point first. Which bench should you file the appeal before? What is the jurisdiction of the various benches? Please note, in tribunal, you have, broadly speaking, there are various categories of benches, but broadly speaking, you have a principal bench sitting at New Delhi where the president is also sitting. Apart from him, 3 members are also sitting. So principal benches are sitting at New Delhi. Apart from the principal bench sitting at New Delhi, we have state bench or state benches sitting at the various states. For example, in Tamil Nadu, again, if you see Tamil Nadu and Puducherry put together, we have 4 benches. We have 2 state benches which are there, 1 sitting, 2 state benches which are there, one in Chennai and other in Madurai. And we have a sitting bench, if I'm right, at Coimbatore, and 1 circuit bench which sits temporarily at Pondicherry. So we have 4 benches. We are lucky to have, as this one, 4 such benches. So therefore, each state can have state benches, whereas there's only 1 principal bench at New Delhi. So be it a principal bench or be it a state bench or benches, we will have 4 members as part of that particular bench, 2 judicial, 2 technical. Very simple. The 2 judicial members are appointed by the center. The technical members, 1 appointed by the center and 1 appointed by the state. Therefore, we have 3 members appointed by the center and 1 member appointed by the state, which is the technical member state. This is how the composition of the state benches will be there. Same is the case with all state benches. The full strength we used to say is 4 members per state bench. Of course, I'm not talking about sitting bench or circuit benches. A full state bench will have a strength of 4. Because what happens in circuit benches, the members of the full bench will go and travel there. For example, here we have in, I guess, Puducherry, members from the Chennai bench or the Madurai bench will go and travel to Puducherry and be there on Wednesdays or Fridays like that. So I'm talking about a full bench will have 4 members, 3 of whom appointed by the center, 1 of whom appointed by the state. Fortunately, we are doing this session in the correct time. As we speak, hardly a few days back, Chennai bench of Tamil Nadu and Puducherry Tribunal, GSTAT, has attained full criticality, just like a nuclear reactor. This Chennai bench of the Tamil Nadu and Puducherry GSTAT has attained full criticality, full strength it has attained. 4 members have been appointed. Therefore, state member was waiting. That state member has also been appointed. Therefore, at least as far as Chennai bench is concerned, we are set to go. And I can personally say based on inside information with whatever little information we have, that it is now sitting. All of you may have known that it is now sitting at a temporary place. The permanent place where the GSTAT will sit has also been identified, and hearings will start very, very soon. It's a matter of a few days, I can say. Before the end of this month, for sure, 1 or 2 weeks, we are seeing the hearings to start at the Chennai bench. At least that much confidence I can say. So therefore, we have state benches with these composition of members. Now, within this, so we have principal bench and state benches. So you can imagine so many states, each will have one bench or many benches. Tamil Nadu and Puducherry together have 4 benches. Now, where should I file this appeal? Should I file? And again, there are other benches also. I'll just tell about the benches, then I'll say where to file. The state benches also, you see, we have a full bench, or we call it as a division bench. So full strength is 4, but each bench will have sub benches. Not all 4 members will be sitting in a particular case. For example, in the Supreme Court, we don't find all the entire collegium sitting on a particular case. That is probably for a 9-bench constitutional matter. So like that, we won't see all 4 members sitting for a particular case. There'll be sub benches. A full bench is called as a divisional bench. 2 members will be there. 1 technical member will be there. 1 judicial member will be there. 2 members will be there sitting on a normal, we can say, a division bench. This is the normal bench. In case the matter is less than 50 lakhs tax impact, small matters are only 50 lakhs tax impact, then in that case, the matter will be heard by a single member bench, provided it is also a recurring matter with no question of law involved. Small, regular 2A, 3B matters are regular matter, routine matter where there is no question of law involved, and the amount is also only 50 lakhs. 2 conditions are there. Then the matter will be listed before the single member bench. Now, this you need not worry about it, because the division now circular has also come few days back, or 2 or 3 weeks back, where the division bench will decide all this allocation. As far as you are concerned, you have only one question to answer. Am I going to file it before the principal bench, or am I going to file it before the state bench? That is the thing that you have to bother. Then within the state bench, how are they going to allocate the matter? That is not your botheration. That is the registry's botheration. That is the bench's botheration. Therefore, you don't worry about it. Either principal or stage, that is the thing that you have to worry. But I'm telling the various categories of benches which are there. So state bench, full division bench is there. Then we have a question of a single member bench is there. Then also we have a question of a larger bench of the tribunal in certain cases where there's a difference of opinion, or where the similar matter is conflicting views are there. Now there are again alternate mechanisms. What I'm telling is from the service tax era, excise era. But now when we have a difference of opinion which is there, or same matters in 2 different states are pending, the president can have the power to transfer the matter to the principal bench. A different mechanism is given. But in service tax era, excise era, where we argued cases where there was such conflicting decisions of the various benches, it normally used to be transferred to the larger bench. So possibly we may see this in GSTAT, or it may not be there because the cases may be transferred to the principal bench also. So therefore, there's a larger bench possibility, normal bench, larger bench 3 members sitting, a normal bench 2 members sitting, and we have a single member bench. But I guess only 2 and 1 member bench we will be able to find in GSTAT. So these are the various types of benches in state. So you need not bother about all this. I'm just telling you that probably when the matter comes up for hearing, you may find this, but at the time of filing, not relevant. At the time of filing, you have to think of only jurisdiction. What is the jurisdiction of the principal bench? What is the jurisdiction of the state bench? That is what you have to be concerned. You cannot file the appeal before the wrong bench. What is the jurisdiction of the principal bench? Let's see first, sitting at New Delhi, where the president is also sitting. Reserved matters are before the principal bench. What are the reserved matters? The first reserved matter, as per the section itself, section 112, so on and so forth, first reserved matter is where one of the issue involved relates to place of supply. Whether the place of supply is Tamil Nadu, sir, or Karnataka, sir, or Delhi, sir. What is the place of supply? If that is the question, so my learned colleague will also speak more on the issues. I'm not going to the issues now. I'm just setting the platform. He will have a very interesting this one to deliver on various issues which are there. So you will see that if any one of the issue involved is relating to place of supply also, then the matter goes to the principal bench. Even one of the issue, you may have 10 issues in the order. One of the issue pertains to that one, matter goes to principal bench. Here, a lot of interpretational problems are there. What if a question is not that of place of supply? It is a question of classification. Whether I'm classic case in point is that of a similar case to that of Dharmendra Mjani, which many of you may know, whether the case, whether my service I'm providing is an intermediary service or not. Simple question. It's not a place of supply question. It's a classification question. It's an export of service related question. So whether my service is intermediary or not, classification question. But if I determine the classification here, the place of supply indirectly gets determined. So will this go before the principal bench is one of the issue. I'm just touching upon it. My learned colleague will speak on many such issues are there. So confusion is there. Probably clarity may be awaited, but we have seen that in a similar matter, in the case of Dow Chemicals, few days back, GST is a very evolving field. You'll have to be updated with things day in, day out. Few days back, Dow Chemicals, principal bench has entertained a very similar matter where the matter of intermediary has been decided by the principal bench. So therefore, what I'm trying to say for the audience sitting here is you have to see if the issue relates to place of supply directly or indirectly. You have to think about it twice. Whether my matter will go to the principal bench or not, whether it is a reserved matter for the principal bench, you have to see. What are the other reserved matter? All advanced ruling, not advanced ruling, all anti-profiteering matters or any appeal relating to an anti-profiteering matters are also reserved before the principal bench. Not many of us may have, so I'm just moving to the next item. Apart from that, there's a notification, specific notification. 3 items are specified. I'll repeat: OIDR related matters, ISD, input service distributor related matters, and if identical question of law is pending in 2 state benches. This is what I was telling earlier. It used to go to larger bench. Now it is reserved before the principal bench. So 2 identical questions, 2 or more identical questions are pending before many state benches. Then the president can reserve the matter to the principal bench. But here again, in this very simple notification, so many interpretations are there which I'm not going into for the want of time. Learned colleague anyway is going to answer all these aspects in the subsequent session. So therefore, reserved matter goes to the principal bench. Non-reserved matters goes to the state bench. Very, very simple. Any other matter, what I've told, 5 matters, 6 matters I've told. Reserved matters. Any other matter goes to the state bench. 2A, 3B reconciliation, 1 versus 3B reconciliation. Incidentally, classification, valuation related questions also state bench only. It's a very important point. Indirect tax practitioners from a long time will know classification, valuation always have a special, this one in indirect tax laws. Even those matters are non-reserved in GST era. It will go only to the state bench only. Very important point to note. So therefore, any unreserved matter goes to the state bench. Even interpretational matters, question of law matters, fine, anything can be there, goes to state bench only, except for the reserved matters, every other matter. So therefore, when your appeal is being filed, please be mindful of whether a matter will go to principal bench or should be filed before the principal bench or before the state bench. So first question is jurisdiction. You have to be very, very mindful. If you file it wrong, now the tribunal has told that we will interstate transfer cases amongst ourselves. But that luxury may be revoked at any point of time. There is no right for you to claim that, no, I filed wrongly. Please transfer it to the correct bench. There is no right for you. Tribunal may do it for now, but there's no right for you. By the time you realize your mistake, limitation would have been gone. Therefore, be mindful of jurisdiction. Second thing you have to be mindful is that of limitation. Now, for second appeal or tribunal appeal, limitation. Before that, what orders can be, quickly what orders can be challenged before the tribunal? Normally, first appellate orders 107 or review orders 108. Directly review orders will come only to the tribunal. It will not go to first appeal. So review orders 108 will directly come to the tribunal. This is a very important point. Many of you should know. If review orders are there, don't go to first appeal, come to tribunal. So 107, 108 matters will come to tribunal. Third is limitation. 3 plus 3 months. 3 months normal time period, 3 months condonation time period. But the important question is 3 months should be calculated from what? 3 plus 3 months should be calculated from what date? That is the more important question. Should it be calculated from the date of issue or date of service or date of communication? These 3 different dates are there. There are enough number of decisions of various high courts. There are 3 notable decisions of the Madras High Court. Many are there, but 3 notable are there. Axiom Gen Next 2025. Pumika Infra Developers 2025, Madras High Court. Shark Tanks, Madurai Bench, Honorable GRSJ, Madurai Bench. Shark Tanks is there. All these 3 give a very, very different scenario as to how to start this calculation of limitation. So that itself is an issue. But having started the calculation 3 months for normal filing without any fetters, plus 3 months condonation if there is a reasonable cause for your delay. You can't claim it as a matter of absolute right. No, sir, procedure we do it. No, it's not an absolute right. Now, what about the question? So 3 plus 3 months. Now the question comes, what is the treatment for more than 6 months? 3 months also over. 3 months condonation also over. What about more than 3 months? So that's where I was mentioning what is the nature of appeal remedy. Can the writ court condone this more than 6 months? GlaxoSmithKline will stand in your way. There are many judgments to the contrary. There are other judgments also, which we will argue in many cases. But in that case, you'll have to see the powers getting diminished further and further once you lose this one. So for any normal discussion, we can say 3 plus 3 months is the normal and condonation time period. So limitation. Third is, and with this, I'll probably take 2 minutes, 3 minutes. I'll conclude because my colleagues also have to speak. So third is that of pre-deposit. 10% you would have paid at first appeal. Another 10% over and above what you have already paid. Again, 112 subsection 8. So many interpretation issues just on this one subsection and one proviso. So many issues are there. So many issues. The wordings of this one causing problems with calculation of pre-deposit. But my advice to all of you is for small matters, don't sweat it. If a small, this one is there, pre-deposit, this one is there, might as well pay it because you don't want to end up on the wrong side. But where the matters are big, amount is big, you'll have to look into all these interpretation issues, which my learned colleague will also point out. So 112 sub-rule 8, 10% pre-deposit of the disputed tax. Admitted tax always 100%. 10% of the disputed tax over and above what is already paid. That's the most important word. Already what is paid at the first appeal, 107 subsection 6. Over and above that, you'll have to pay another 10%. Maximum, minimum, all this is there. I'm not going to, but normally 10% of the disputed tax. So pre-deposit is the third. So L, J, P we have covered. Procedure, P also covers procedure. Form APL file for taxpayer appeal. Accompanied by pre-deposit payment, you'll have to make. Deposit you'll have to make. Court fee you'll have to file. Minimum 5,000, maximum 25,000. Court fee you have to keep it ready. Adequate court fee should be there while filing. Correct form should be there. Correct fee should be there. Documents to accompany, Rule 21. Form of appeal, Rule 18. All these should be proper. Procedure rules you have to be mindful. If you don't do that, there is a bench, not like first appeal, kuch bhi chalega, right? Nothing like that. Here you have a registry which will scrutinize your application, send it back within 7 days if there's a defect. If there's a defect, sending it back to you. You will be given time to rectify the defect, 30 days. If you don't rectify it within 30 days, please note you will be given only a provisional acknowledgement. Be very mindful when you file an appeal. If defect is there, they'll list it. You'll have to correct the defect within 30 days. If you don't correct the defect within 30 days, matter will be listed before bench. You'll have to go and argue and make good the defects. Still, you're not doing it. The provisional acknowledgement will be rejected. So your appeal number will be removed and you'll have to file a fresh appeal and limitation becomes a problem here. Therefore, please don't take second appeal lightly. Where the defect is not made good, the provisional acknowledgement goes and you'll have to file a new appeal. Of course, we will have enough cases here also in this regard. Whether should we take the original date itself or once the number is removed, the new date should be considered. We'll have enough batch cases, I'm sure, on this subject. But if you look at the law as it stands, this is what is the thing. So therefore, be very mindful of procedure and be very mindful of the procedure rules. Now, once a tribunal appeal you have filed, hearings will happen. Please note, as I said, tribunal is a quasi-judicial body. It has its own powers. It has the power to regulate its own procedure. It is not bound by CPC. Hearings will happen. Members will be arguing. You'll have to make your case. My learned colleagues will speak on this. Right? Adjournment, so on and so forth. When the order should be passed, wherever possible within a year. Order is erroneous, patent erroneous. Then we have section 113, rectification is possible. Separate section is there for tribunal. So all these things, whether tribunal can admit additional evidence, I already talked about this. Very difficult. You'll have to prove reasonable cause. Rule 45, Rule 110 of the CGST rules, Rule 45 of the procedure rules, additional evidence. Tribunal can have the powers. I told you it has inherent powers, but not unlimited powers. Additional grounds can you take? Again, possible, but difficult. So additional grounds, additional evidence. Please note it's the final fact-finding authority. Therefore, it will go all out to find out the facts and dispense justice and not dispose your case. Not just dispose your case. You will see a proper functioning tribunal from what we have had the experience in the GSTAT. Therefore, with this small introduction to GSTAT, I will conclude my presentation. Therefore, please note again to reiterate, ladies and gentlemen, tribunal is a very unique body. It's a very special, occupies a very special place in indirect tax practice, just like direct tax. Occupies a very special place. The bench and the bar have, especially here in Chennai, have set a very high bar, we can say, if I can use the word. Members who have practiced here have gone on to be, or who are part of the bar have gone on to become High Court and Supreme Court judges. So we have a very good benchmark here. I hope the tradition will be continued in GSTAT also. Needless to say, same is the case with that of the bar. So therefore, I would request all the members to, it's the right time that you have come to this session. Please don't take this very lightly. Please take this, be very thorough with all the rules and procedure rules, so on and so forth. You have a very high bar to set. So this small conclusion. So thank you for the opportunity, ladies and gentlemen. So thank you to Shreyas for the opportunity. So I think Harsh, it's over to you.
Thank you, MSP sir, for that exceptional breakdown on the foundational framework. As always, you have hit the nail on the head with that classic remark of yours of LJP, comparing it with the CJP. So your clear explanation of the fundamental appellate law and the tribunal framework gives our clients and corporate partners the perfect starting point to understand this new system. Now, building on directly with that foundation, our next speaker is CA J. Srinivasan. Srinivasan sir, before joining the firm, he was a part of the national team dealing with the tax controversy and dispute resolutions at one of the Big Four consulting firms. He regularly advises multinational corporations on complex indirect tax matters. Today, he will be guiding us through the crucial litigative issues in the GSTAT appeals, focusing heavily on the critical rules for the pre-deposit jurisdiction, etc. Welcome, Srinivasan sir. The floor is yours.
Good evening, everyone. Am I audible?
Yes, sir. You're audible.
Yeah. So thanks, Shreyas, for the opportunity. So as Mr. Sarana Prabhu very clearly indicated that the focus is primarily, as of now, because the due date is 30th of June, the focus is mainly on admission of the appeals. So the issues that I am going to put forth are more issues relating to admission of the appeal before the tribunal. I have just divided the issues into two parts. One, admission of appeal insofar as jurisdiction is concerned. Second, admission of appeal insofar as payment of pre-deposit is concerned. So I would broadly discuss 5 issues under jurisdiction and 5 issues under the pre-deposit section. And I will focus very specifically on issues that are practical because there are other legal issues where possibly we have not come across any disputes, but there are legal issues which are having practical implications for now insofar as admission is concerned. I would like to focus on that. The first part is with respect to the jurisdiction, as to which forum you should approach in order to agitate the matter where an order has been passed by the Commission of Appeals. That is the first part I would like to focus on. Here there are broadly 5 issues that I would like to cover in this session, starting with a typical case of a DGGA investigation. As you will all be aware that any DGGA investigation, they will by default take not a single tax period or single financial year. You always would have seen multiple financial years and tax periods being covered. So what typically happens is a DGGA investigation is concluded. with a show cause notice for multiple financial years. Subsequent to that, the adjudicating authority passes an order, and subsequent to that, you file an appeal. First appellate authority decides against you. Now, here the problem insofar as jurisdiction is concerned is this. So the practice, if you look at the central tax authorities for now, of course, there is a larger question of whether bunching of orders are allowed, bunching of notices are allowed, etc. Larger question is there. It is pending before the high courts. It is pending before the Supreme Courts. Divergent views. I'm not going into that. But the simple point for those who are not agitating the bunching, but they are ultimately approaching the tribunal, insofar as bunching of orders is concerned, the first issue that arises for them insofar as jurisdiction is concerned is this. In all those cases where multi-locations are involved in a DGT matter, for example, I'm X Limited, there is one issue which is taken by the authority, DGT authority, and this issue is not limited specifically to only one of my branches. I have branches across India. What DGT generally will do is, when they issue a notice, they will issue a consolidated notice at one location. For example, I'm headquartered at Maharashtra, and DGT Maharashtra has taken up this matter. Typically, show cause notice is issued by DGT Maharashtra covering all the locations. And subsequently, order is also passed in a consolidated way at Maharashtra. And subsequent to that, appeal is also filed with the Maharashtra Appellate Authority, Central Appellate Authority. Now the question is, because there are multi-locations involved, let's say Tamil Nadu is involved, Andhra Pradesh is involved, Maharashtra is also involved. 3 locations are involved. The question that arises is, should I file an appeal before Tamil Nadu GSTAT or Maharashtra GSTAT or AP GSTAT is the question that arises on the jurisdiction. So at present, looking at the practice adopted by the central authorities, what they are doing is they are uploading one consolidated order in the state of Maharashtra. So therefore, the suggestion, and we in lot of sessions the tribunal members also conducted, when we put forth this question to the members, they have found that the appellate authority, the state where the appellate authority has passed this order, that is the state where you have to file this GSTAT appeal, which means in this case, Maharashtra GSTAT is the relevant authority in against the forum where you are supposed to file the appeal. This is one issue which is very prominent, which you would have seen in multiple cases. And here one important point is the state government, depending on which state you are looking at, follows a completely different procedure insofar as issues involving multi-locations are concerned. What they do is they do not consolidate all the states. They pass orders for respective states alone. So if you are getting an order for Maharashtra separately, Andhra Pradesh separately, and Tamil Nadu separately, you have to file an appeal with the respect to GSTAT. This is with respect to state government orders are concerned. Predominantly, they do not combine multiple states. But there is one unique scenario which we have seen recently, is that the adjudication happened at a central level. The appeal was also heard at the central level, but unfortunately, multiple DRC 07 or multiple orders are being passed in the respective jurisdiction. That is, in our case, Tamil Nadu, Andhra Pradesh, and Maharashtra. So again, this is a practical challenge. Our view is you have to still file an appeal before the Maharashtra GSTAT and ask the authority who passed this order to pass one consolidated order or upload one consolidated order in the state of Maharashtra, because based on the interaction with the members, with the GSTAT members, their view is the appellate authority in whose jurisdiction the matter was heard, that is the relevant jurisdiction in which appeal has to be filed. So therefore, that is one issue which practically many of us are facing. So therefore, this is one. Second, and most importantly, which everyone would have seen this, the issue relating to place of supply, as the previous speaker very clearly said, that the classification of bench as to state bench and principal bench is primarily on the fact that whether the issue, the underlying issue of the order that we are going to agitate relates to place of supply or not. The natural question is, how do you define an issue as to whether it is a place of supply issue or not? Interestingly, if you look at if you look at a lot of advanced rulings on this aspect, why I'm taking advanced ruling is, if you are approaching the advanced ruling authority, you had a set of questions for which you can approach the advanced ruling. Place of supply matter, you can never go to an advanced ruling. That is the indirect implication, because there are 7 questions which you can put before the advanced ruling authority. Place of supply is not one of the questions. If you look at the advanced rulings that have been given, there is a consistent approach that if you are able to make up a case, though it relates to place of supply, but if you are able to make out a case as if the case relates to determination of tax liability, then advanced ruling authorities did admit the application, they heard the matter, and they finally came up with a ruling. Now, one critical distinction one has to make between the advanced ruling and GSTAT is this. Unlike advanced ruling authority, GSTAT is not having a list of questions that GSTAT can adjudicate or cannot adjudicate, except the place of supply. So therefore, you all know for a fact, let us take an example and understand this. So typical case of place of supply involvement, where this dispute arises, is your export transaction. You have typically 5 conditions that you have to satisfy in case you have to treat your transaction as export of service. What happens is, one of the question that arises for you to treat a transaction as export is place of supply should be outside India. Now, if you look at all the advanced rulings, predominant advanced rulings, the application is made before the authority in such a manner that whether this transaction amounts to exports or not, and consequently should I pay tax or not. This is how the question was put before the advanced ruling authorities. And advanced ruling authority says, if you're asking me whether I have to pay tax or not, this question relates to determination of tax liability. Determination of tax liability is one of the questions which the advanced ruling authority can admit. Therefore, this question is a relevant question which you can pose before the advanced ruling authority, is what they said. And they said this is not an issue relating to place of supply. Therefore, there is no bar you coming to the advanced ruling authority to see whether the ruling authority can admit the application or not. Here, one critical distinction is, according to me, this issue is not there before GSTAT. Why? Because there is no competition between questions that the GSTAT, unlike specific 7 questions that you have to post before the advanced ruling authority. If you look at the relevant provisions in the tribunal related provisions, 1095 proviso very categorically says the cases in which any one of the issues involved relates to place of supply, then it should be heard by the principal bench. Now, you can always have a place of supply issue which will ultimately decide determination of tax liability also. In case of advanced ruling authority, if there is a dispute between determination of tax liability and place of supply, the authority will decide whether it can admit the application or not. That is not the case with GSTAT. Even if you have a fight between determination of tax liability and place of supply, according to me, this has to be heard by the principal bench, because you don't have a list of questions that the GSTAT can hear or not hear. It is only before the advanced ruling authority that you have a list of questions. So therefore, I do not see any contradiction insofar as the rulings that were given by the advanced ruling authorities on whether an application can be admitted before the advanced ruling authority or not, if the matter relates to determination of tax liability, which incidentally has place of supply. According to me, it is very clear that even if it relates to determination of tax liability, if place of supply becomes one of the issue to be adjudicated or to be heard by the tribunal, it has to be heard by the principal bench, according to me. So I do not see the issues that we were looking at before the advanced ruling authority as an issue before the tribunal, because there are no questions that you can put forth before the tribunal, unlike advanced ruling authority, which you have a specific set of questions. This is issue number 2 with respect to the jurisdiction as to which bench you should approach in case of filing an appeal. And you also have even more diluted version. Just to conclude this point, I have recently seen a case where the question relates to export of service or not, but the department has disputed the export of service on 2 counts. One, there is a dispute on whether you have received the forex or not. Second, the dispute also is place of supply. Now here again, according to me, proviso, since it says one of the issues involved relates to place of supply. So I would think, because one of the issue to be decided in this case relates to place of supply, this cannot be heard by the state bench. This has to be heard only by the principal bench. That is my view. This is on the second aspect of the jurisdiction, which many of us are facing. Third and most important aspect, again, which is related to aspect number one. I should have combined it along with one. See, you would be aware that there is a circular issued by the CBIC in accordance with section 120 of CGST Act, read with 168 of CGST Act, whereby the board has fixed monetary limits below which they will not ideally prefer an appeal before the GSTAT. There are exceptions where they can prefer appeal even if the monetary limit is not exceeding the prescribed limit. Now here, interestingly, one of the cases that we are having where a department has filed an appeal, if you look at the threshold limit is 20 lakhs before the GSTAT. In one interesting case, the orders have been bunched. There are 4 years involved in this order. If you look at year-wise, year 1, year 2 does have the total tax liability involved more than 20 lakhs. If you look at year 3 and year 4, the tax liability is actually not more than 20 lakhs. But because there is a consolidated order which has been uploaded and there is a consolidated appeal which has been filed with the department, the question that arises is whether the department appeal to the extent of year number 3 and year number 4, whether it can withstand the monetary limit or threshold which has been imposed by the circular. This is one issue which we have to be very, very careful, especially when the orders are bunched. This issue arises primarily in cases where the orders are being bunched. This you have to be careful whenever department files an appeal. Look at whether all put together it is more than 20 lakhs and also individually it is more than 20 lakhs. This is something which is very, very critical on challenging the department appeal on jurisdiction itself insofar as monetary limit is concerned. This is issue number 3, which I thought I would try to address. Issue number 4 again is more to do with issue number 2, a consequence of issue number 2. You will be aware that once state bench decides a matter, the appeal lies before the High Court. If principal bench decides the matter, it goes to Supreme Court. Now the problem again before the High Court is because of the advance ruling that we discussed, where divergent views were expressed. What if state bench completely goes to the matter which involves place of supply, let's say export of services? State bench completely looks to the matter and finally it gives an order saying it is export of service. And it assumes that since it is related to determination of tax liability, it has the power to determine this particular matter or hear this matter. Now, whether High Court can it now take a call that this matter inherently has place of supply to be decided for determination of tax liability, therefore state bench whatever it decided is null and void. This is one question which again is something where you don't have an immediate answer. Therefore, my suggestion will be ideally place of supply once you see it is better to go before the principal bench. One advantage that you will have is if at all they feel that it is not a matter related to place of supply, it is related to determination of tax. As of now, they have a mechanism whereby they will transfer the matter. So this you have to be very, very careful, because even though you may win the case before the GSTAT, there is every possibility that department will file an appeal before the High Court, not on merit, simply saying state bench never had a jurisdiction to hear this matter. This is something which again is very, very critical insofar as appeal to High Court is concerned. The last aspect that I would like to discuss on the jurisdiction itself is you have a rectification of orders. You know for a fact that the authorities have power to rectify the order under section 161 of CGST Act. The problem with all rectification is this: rectification can be done only if there is a mistake or error apparent on the face of record. The problem here is the authority will never go into whether you have merits. So they will not review the stand taken. They will only see whether there is an error which is apparent on the face of record. So which means what happens is the authority decides that there is no error apparent on the face of the record. Now you are agitated against this order because you still feel there is an error apparent on the face of record. The problem at present, practically what we are facing is when, especially state, we have seen this. State never treats this as an administrative decision. That is, they do not decide this matter as to whether the rejection of rectification is valid or not, which means they do not hear the matter on whether there is error on the face of the record or not, apparent on the face of the record or not. Rather, they go into the merits. They decide on merits. Now what happens is, despite the fact that you might have actually put forth before the appellate authority that there is an error apparent on the face of record, therefore you applied for rectification, the authority, adjudicating authority, did not adjudicate on that aspect. Now appellate authority decides on merits. Now you come to the GSTAT. Now, should the GSTAT hear this matter on the administrative ground on whether there is an error apparent on the face of record, or it will go into the merits or not? This is a question which is certainly open. Most importantly, what happens is both the GST portal as well as appellate authorities, as of now, do not ask you to pay pre-deposit if it is an administrative order, because all the rectification orders, if you look at the portal, wherever rectification orders are completely rejected, you apply for rectification, your rectification is completely rejected, there is no pre-deposit requirement that you have to pay. That's how it is there designed in the portal. That's how the department also categorizes. They categorize the appeal itself into two grounds, or two, they bifurcate into two aspects. One, administrative, second, non-administrative. So now the problem that we are practically facing is, despite the fact that we have actually a lot of matters where we are going to file before the GSTAT, only on the ground on error apparent on the face of record, the department is insisting on pre-deposit. There is one more layer to this. What happens is, there is a parallel rectification application that you file, which is getting rejected, against which you go for an appeal. There is already an original order where there is a demand against which you agitate separately. There are practices, especially in the state, where they are asking you to pay pre-deposit on both the orders, administrative and non-administrative. Because for them, there are two appeals. They don't give stay unless you make pre-deposit against each of the orders. So, insofar as rectification is concerned, it is, according to me, it is very, very clear. It is administrative in nature. Tribunal also, if the rectification has been rejected, it cannot go beyond the question of whether there is an error apparent on the face of record. That is the limited question tribunal can answer. This again, I thought I will discuss on the jurisdiction itself, on whether tribunal can even go into the merits of the case, despite the prevalent practice being that first appellate authority, beyond answering whether there is an error on the face of record, it also goes into the merits. This will become a problem before the tribunal, depending on whether the matter is in the favor of the department, whether the department has gone for an appeal or you have gone for an appeal. You will naturally take a stand. But according to me, the question that is to be decided with the tribunal is purely whether there is an error on the face of record. These are the 5 issues I thought I will cover on the jurisdiction, in as much as whether the proper forum in which it can be filed, whether the state bench can hear the matter, principal bench can hear the matter, whether tax effect, whether department at all can file an appeal in accordance with circular, etc. Now coming to some critical issues relating to pre-deposit. As I said, we are at the very, very beginning stage of the tribunal being functional. So I'm focusing strictly on admission. So one of the key critical aspects for admission, as you all know, is provisions relating to pre-deposit. Unless you make the payment of pre-deposit, your appeal will not be accepted. There is absolutely no leeway. There is absolutely no waiver that the tribunal can give. This is very, very clear. The pre-deposit provisions have been challenged multiple times. It has been consistently held that pre-deposit, no waiver can be given. Now, coming to issues involved in pre-deposit. See, what happens is, there are two types of appeals. One is a department appeal. Second is the assessee who files an appeal. The first scenario, let us take, first adjudicating order was in your favor. Now, against this order, department went for an appeal. The first question that arises is, if department goes for an appeal, should the assessee pay pre-deposit? The answer is very clearly no. The provisions are very, very clear. For a department appeal, pre-deposit is never required. So adjudicating authority has passed an order in your favor. The appeal has been filed with the department before the first appellate authority. Now, because there is an adverse order passed by the first appellate authority, naturally you will prefer an appeal now. When you are preferring the appeal, the question is, should you pay 10% of the tax in dispute or should you pay 20% of the tax in dispute? The department is not having proper clarity on this matter. They are saying you have to pay 20%. According to me, the language of section 112 subsection 8 is very, very clear. It very categorically says a sum equal to 10% of tax in dispute in addition to the amount paid under section 107(6). It is what the provision says, which essentially means at the first appellate authority level, if some amount is payable by you and you have paid such amount plus additional 10% is what the provision says. At the first level, because there was a favorable order at the adjudication level, I am not supposed to pay any pre-deposit. It was a department appeal. Therefore, the amount paid under 107(6) is 0. Therefore, according to me, what you have to pay is only 10% of the tax in dispute against the order passed by the first appellate authority. Only 10% you are supposed to pay. This is issue number 1 on pre-deposit. Issue number 2, again, this issue has arisen primarily because of the amendment which was made by the Finance Act 2025, which was effective from 1st October 2025, where there was a new provision that was introduced, which said that in cases where order demanding penalty without demand of any tax, no appeal can be filed unless you pay 10% of the penalty. So basically, before October 2025, if you have only penalty order, so order does not have any tax liability, order has only penalty liability, nothing else is there. Prior to 1/10/2025, you don't pay any pre-deposit, you just simply file an appeal. Now, the provision that was introduced in October 2025 says, if you have an order, the order does not have any tax liability, it only has penalty liability. It says you are supposed to pay 10% on the penalty, is what it says. Now, the first problem that arises is, which order is the relevant order for me to apply this provision, which came from 1st October 2025, rather which was notified from 1st October 2025. Let us take a very simple scenario. There was an order that was passed on 1st September 2025. Now that order has only penalty. Because the tribunal was never functional, because the filing etc. was never possible, I was waiting till the tribunal was functional. Now I want to file an appeal. The order involves only penalty, 100 crores penalty. Typical fake invoicing cases, what happens is for one of the parties, they levy only penalty. Now I want to file an appeal now. The question is, before the GSTAT, should I pay 10% of pre-deposit on penalty? According to me, because the provision that was enacted by the parliament is imposing additional liability, I would think that because the order was passed and was communicated on 1st September 2025, for this order, pre-deposit of 10% is not required. But department very, very categorically has taken a position. It is only the filing date, whatever may be the provisions that are prevalent on the filing date, that will be the relevant provision. Therefore, you have to pay pre-deposit for all orders against which you file an appeal post 1st October 2025. This is certainly an issue which we will be coming across, especially where orders involve only penalty. Secondly, what also happens is, this already I discussed, same issue. When you filed the first appeal, let us assume 2024 adjudication order was passed. Your order involved only penalty. You filed an appeal before the first appellate authority where you did not pay any pre-deposit. Naturally, because there was no provision which was making you to pay this pre-deposit. After the first appellate authority, passes an order against you, you now file an appeal before the tribunal. The question that again arises is whether you should pay 20% or 10%. Again, the same view holds that I was not supposed to pay, as per law, any pre-deposit under 107(6) at that point in time. Therefore, I can only pay 10% of the tax in dispute after the order was passed by the first appellate authority. So this again is an issue. Department again insists on 20%, but according to me, the provisions are very clear. It is always the amount already paid at the first level plus balance tax in dispute. First level, no amount was payable. Therefore, consequently, there is no question of amount being paid. This is next issue which I wanted to broadly touch upon. Now, the third issue which I would like to discuss, which you would have seen in multiple instances, is whenever there is an investigation, inspection, search, etc., the department always invariably forces the assessee to pay some tax. And what happens is, because there is a pressure from the department, we do not give a letter saying that I have paid the tax under protest, etc. We just pay some amount, 1 crore, 2 crores, etc. Now, the understanding has always been that whatever amount that you have paid during inspection, investigation, etc., can always be adjusted as pre-deposit when you file an appeal before first appellate authority, or for that matter before the second appellate authority. But because there are court judgments, unfortunately, very unfortunately, which says that you cannot adjust the amounts paid under investigation, especially there are 1 or 2 Madras High Court judgments which say that, though in one case facts are slightly different, we are now facing a situation as to whether we should again look at pre-deposit independent to the amount that we paid under investigation or not. This is one issue which is there. According to me, it is very, very clear. The amounts that are paid at any point in time before the adjudication happened, or even during the adjudication, unless and until the department is able to prove that it is the admitted tax liability, you cannot take away the fact that that amount can be used or adjusted against the pre-deposit. The only problem that arises is there is only a DRC 03 payment that is made, which will say voluntary. Now, naturally there is no option available for you to upload some letter, etc., in the GST portal. So therefore, whether it is paid under protest or not is always a question which is there. So long as if you have agitated the matter before the adjudicating authority, appellate authority, etc., I would think that the amount that was paid under investigation shall be treated as an amount paid under protest, and that shall be adjusted against the pre-deposit requirements under 107 or for that matter 112. This is the third issue I thought of just highlighting. The next issue, again, this issue was there in pre-GST regime where excise service tax matters, we had this issue. The issue relates to adjustment of the amount paid as pre-deposit at the first level. Now, let us take a scenario where an adjudicating order was passed. The adjudicating order, let's say, is passed for 10 crores. I file an appeal before the first appellate authority. Now, first appellate authority grants partial relief whereby to the extent of 4 crores, the appellate authority says you are not liable to pay 4 crores, you are liable to pay only 6 crores. Now, what happens in this case is I go for an appeal against the 6 crore demand. Now, department also goes for an appeal against the 4 crore demand. This is typically happens. Now, the question is this. When department goes for an appeal against 6 crore demand before the GSTAT, naturally, I'm not supposed to pay any, against the 4 crore demand, naturally, I need not pay any pre-deposit because the 4 crores is in my favor. Department appeal, I'm never supposed to pay pre-deposit. The question is, when I file an appeal against the 6 crore demand, which got confirmed by the appellate authority, can I adjust the 4 crore into 10%, which is 40 lakhs, against the 6 crore into 10%, which is 60 lakhs. If you look at strictly the language of the provision, the language employed under 112(8), it seems to be that you cannot adjust. Though logically it can be adjusted. There is in fact a circular, there are instructions on the very same issue in the pre-GST regime. Before GSTAT, we are adjusting it. Unfortunately, there is no circular or notification to this effect. But 112(8) never talks about the situation. It only says you take the amount that you already paid at first appellate level and you pay on top of that 10% of tax in dispute. That's how the language is. So strictly going by 112(8), if you interpret 112(8) very strictly, you cannot adjust the 40 lakhs that you paid at the first appeal level against the second appeal before the GSTAT. You have to pay a fresh 60 lakhs. But according to me, because this was an issue that arose during the pre-GST regime and a circular was issued clarifying that it can be adjusted, according to me, that should hold good. Otherwise, safer side is to get a refund for 40 lakhs and then pay 60 lakhs separately as pre-deposit. This again, practically, we will be facing this issue when we file appeal before the GSTAT. And the last issue which I would like to discuss and conclude on this particular pre-deposit related matter is which was also touched upon by Sarna Babu, is the date of communication. The problem with so this is more to do with the limitation. So you all know for a fact that we are supposed to file the GSTAT appeal within 3 months. Now, the date of 3 months, this has been extended. The last date now for the orders that are passed before 1st April 2026 is 30th June 2020. The problem here, insofar as calculation of limitation is concerned, is limitation is calculated from the date of communication of an order. Now, this date of communication, unfortunately, has been a subject matter of dispute right from 2017 onwards. You have divergent views taken by various high courts. Andhra Pradesh has a view, Madras High Court has a view, Karnataka High Court has a view, Bombay High Court has a view, Allahabad High Court has a view. In fact, very unfortunately, even in Madras High Court, there are more than 3 views. One view says you have to read section 169, which talks about date of service of order in a conjunctive way. Therefore, unless all modes are explored, at least 1 or 2 modes are explored, it is not deemed to have been communicated. One judgment says once the order is uploaded in the portal, that is the date of communication. One judgment goes one step ahead, interprets the entire provision, and it defines what communication means. It refers to some of the legal dictionaries and says unless you are able to establish that assessee has seen that order, you cannot say that it is date of communication. It laid down a completely different principle altogether. And that judgment has given, in fact, recommendation to the council on how in a technological environment or digital environment, how we can establish communication. That's, in fact, I would say a very recent judgment because it considers all the previous judgments of other high courts and even the Madras High Court. So you have varied judgments on what date of communication means. Always, to be on a safer side, it is better that we take 30th June as a date, even if an order has been passed after April 2026, primarily because you know for a fact that all the orders at the first appellate level, it is communicated by email. There is an upload which happens in the portal. In the portal, date of upload is a separate date. In the order, date of issue is a different date. You also receive a speed post. So many dates are there. You always try to take the earliest date to not take any chance, especially for orders where the due date, if you feel it is 30th June. I will tell you a classic case where the problem arises. Most of the orders passed by the central government officers at the appellate level are manual orders. They never upload the order. For example, the recent case I saw, there is an order which has been passed, which has been issued by the First Appellate Authority, which is dated January 2026. Now that order has been communicated by email in February 2026. But the officer has uploaded that order during April 2026. To be precise, 25th April 2026. If you take the interpretation that for orders which have been communicated, if you deem the date of communication to be the date on which you receive the speed post, naturally your due date is 30th June. If you treat the date of upload, because if you go to the portal always considers the date of upload to be the date of communication, which is unfortunate. Now an option to specify the date of communication. According to me, in this case, you discard or disregard the portal date because portal is only focused on what date it is getting uploaded. From that date only it calculates 3 months. So if you strictly look at the timeline, according to me, you take the date of the exact date when the speed post arrived at your registered premise. That date, if you take, the last date for filing appeal will be 30th June 2026. I request not to take any chance, whoever is having such a situation. and there are multiple cases where the orders are still manually passed, and people are requesting the officers to upload the order. For all you might know, all the orders are now getting uploaded in the month of June. Do not treat those orders as June orders. If you have received those orders prior to April 2026, it is better to assume that the due date is 30th June 2026. Otherwise, the admission of appeal may be questioned. Department may very much agitate on the limitation that your appeal is time barred. And most importantly, one critical interpretation issue which is there, which I do not know whether tribunal may come up with that particular view, because tribunal, whenever there are some meetings that are being conducted, outreach programs, they are very, very clear on condemnation that if any appeal is being filed after 30th June 2026, the stand of the tribunal for now is it will not condone the delay because they feel that sufficient time has been given. The bigger problem is, assume for a moment that condemnation is not given by the tribunal, you go to the High Court. The problem is you have a language in section 112 where the condemnation period, if you read the provisions relating to condemnation, the provision talks about a period extending the period of original. So 3 months is the relevant period for you to file an appeal, after which subsequently 3 more months you are given for condemnation. If you look at the language, it says appellate tribunal may admit an appeal within 3 months after the expiry of the period referred in subsection 1, is what section 112(6) says. The problem here is you have 2 dates for now. One date is 3 months after the expiry of the 3 months from the date of order. This is one date. Because the notification has been issued by the government on the recommendation of the council, 30th June is one date which has been notified by the government. If one interprets very strictly, the tribunal can take a stand that I will not admit an appeal beyond 30th June 2026 for an order which was passed in 2025, let's say early 2025, because the language used in 112(6) is after the expiry of the period referred to in subsection 1. So period can never be one single date because notification only talks about single date. Period always is an interval. So 3 months is an interval. So they may always say for an order which is passed in 2025, date is notified as 30th June 2026. If you are filing in July, I am afraid that tribunal may take a position that there is no period which is beyond 3 months which is available for you, because what was notified was only a date. Date is never a period. That stand tribunal may very well take. With this, I thought I will conclude the broad issues that are involved, primarily relating to admission. There are many such issues as well. Considering the paucity of time, I would just like to conclude with this. Over to Harsh.
Thank you, Srinivasan sir, for that highly practical section, breaking down the absolute realities of the tribunal's jurisdiction and the crucial issues on the pre-deposit. You have hit the every crucial pain point which our clients may face during the filing of the appeals. Thank you for bringing such intense clarity to these litigative issues. Now, next to walk us through the tribunal appeal strategy, it's my absolute privilege to introduce NV Balaji sir. NV Balaji sir is a formidable chartered accountant with 23 years of experience in the field of taxation before transitioning into the law, and now has been practicing as an advocate at the Madras High Court for over 15 years. He has a 360-degree view of the law, having represented the Government of India as a senior standing counsel for the Department of Income Tax, while also routinely representing major global and Indian MNCs before the tax authorities, tribunals, and the High Court. We could not ask for a better expert to guide us on the strategy. Now, the floor is yours, Balaji sir.
Sizably on filing of the appeals before the tribunal, my previous speaker, Srinivasan, has dealt with. So further, the topic that I may be touching upon little is with reference to the strategy that is to be adopted, whether at all you should immediately rush to the appellate forum, or is there a scope for you to challenge the orders that are passed by the authorities before the High Court through the writ jurisdiction. I believe the fundamental rules that any assessee should look for is not the writ remedy. The writ remedy, as all of you are aware, is only an extraordinary remedy. In the normal course, it would be fine and the best that you travel through the path of appellate proceedings. Writ should always be an exception. That's how the court will also view it. Many times we come across clients saying, no, it is too harsh that we need to pay so much of pre-deposit. Therefore, you move the writ court, get us some stay or get us some order by which it is quashed. I believe this is a flaw in thinking of the assessees, that we should rush to the court because the assessee does not have money to pay or the demand is too huge. Such an approach is something which the court would either appreciate. For any order to be challenged, the fundamental rule for being challenged is that whether there is an absence of jurisdiction or that the principles of natural justice is not followed. If we are able to show these two or either of these two conditions being present, it would be comfortable for an issue to be taken through a writ. In all other cases, I think the assessees will have to grind the mills of following the statutory procedures, and notwithstanding the discomfort that they would have in the form of having required to pay the the pre-deposits. One of the issues that was taken by the previous speaker was with reference to the time limits. And he also referred to GlaxoSmithKline Supreme Court decision to say, the time limit is very essential. If we don't approach even the writ courts in time, like what one is required to do in respect of filing of the appeal, then even the writ court will not give any assistance or give any remedy to the assessee. That's how courts have taken the view. But nevertheless, fortunately, in matters where the orders are ex parte, Madras High Court and now a few other high courts as well have taken the view in such cases the assessee also require an opportunity of being heard. Therefore, instead of giving an appellate remedy to the assessee, they quash the very original order. Therefore, it becomes essential for the assessees to seek the prayer to quash the original order. Recently, I saw, a writ petition being filed where the petitioner has challenged the appellate order. He did not challenge the original order at all. Thereby, the court said if appellate order is, against the assessee on the ground it is time barred, there is nothing that the High Court could do. And the writ will not lie against that. Therefore, it dismissed, fortunately in that case, to the assessee, a liberty to file another appeal challenging the order in original. So in such cases, wherever it is quite possible that it is an ex parte order, not knowing that you could approach the High Court as CS, approach the appellate authority and file the appeal. The appellate authority naturally not being considered that it is within time that they had dismissed the appeal. When you go against such order, naturally, even in tribunal, such appeals will only get dismissed because the only issue that you can challenge is whether the first appellate authority was right in rejecting the appeal on the ground that that it is not filed in time as time barred. Naturally, the further appellate authority, the tribunal, will also uphold the appellate authority's order only, first appellate's order. Therefore, the only remedy that would be left over for the SC is to file the writ petition. But in such writ petitions, it would be just and essential that you don't challenge the appellate order alone. Also challenge the original order on the ground, some ground, possibly, there was no opportunity, the SC could not avail the opportunity, or for whatever reason, explain such reason, seek to quash both the original order in original and the consequential appellate order. Thereby, the matter could go back to the original authority for re-adjudication. So thereby, it becomes very important for you to strategize stage at which and reason with which one has to approach the writ jurisdiction. Also, in the writ petitions, it cannot be on just merits. Thereby, it becomes that there is a possibility of an alternate remedy, which the appellate authorities could always. So such things will also not be entertained unless, again, with a caveat, the assessors are able to show that it had brought to the attention of the lower authorities that these are all the settled positions. The officer did not distinguish, did not give reason as to why it is unacceptable, etc., and still went ahead. In such cases, it will fall within the ambit, as I have told, on the lack of opportunity. That you put across that there is a binding order, still the officer does not accept because for him it is something which is pending before further appeal, etc. Whatever be the reason, that if we are able to show that there is a lack of opportunity, without such thing, it would be impossible for us to drive the case before the court. So I would only, with the tribunal having now more or less coming to operation shortly, it would be very essential for the assessees to take through the statutory route as far as possible, unless as a case to case one has to find out what could be the remedy. On appellate side, this is as regards orders in original, which will travel to the first appellate authority. Against first appellate authority's orders, there are cases which are to be taken on further appeal before the tribunal which is constituted to function now. In such cases, as one of my previous speakers had put across, it would be essential that it is a thumb rule always. Put facts very well in advance, maybe before the original authority, or for some reason you are not able to, before the first appellate authority, he has to seek the remand report, etc., from the assessing officer on fresh facts if filed, etc. Before second appellate authority as well, it would not be unjust for an assessee to say that further facts need to be brought. Only thing is, it would require, as one would do before the first appellate authority, as to why that could not be produced before the lower authorities. Liberty is to be sought from the tribunal. Then further essential facts, after all, the tribunal, as all of us are aware, is only a final fact-finding authority. Therefore, further facts which are relevant for the adjudication, which were not placed, may be placed with the reason, and of course, the tribunal has the discretion to admit or reject with the opportunity to the other side. Therefore, placing facts will not be possible beyond tribunal. Similarly, questions that have been taken for adjudication before, say, first appellate authority, you believe further questions are to be raised. I believe it is settled through many cases that the tribunal is not restricted to the pleadings or issues raised in the first appellate authority proceedings alone. The tribunal could, if no further facts are required, and that could be inferred from the facts already on record, the tribunal could always entertain further questions, even if it is questions of law which requires to be adjudicated. The tribunal could always do it. Now that I said the tribunal could also entertain further facts, naturally the tribunal could also entertain further issues that would require adjudication on facts as well. So the tribunal is not barred to entertain only the issues, facts which were before the lower authorities alone. Of course, it will therefore it becomes essential for the assessees that the bus missed in the first appellate and the assessing officers level should definitely be filled in with the appropriate facts and law, at least before the tribunal, failing which they have permanently lost the bus. So this becomes, to my mind, an essential factor in the tribunal filings. So bringing up facts originally, additional, which were before first appellate authority, and the further facts, similarly further questions of law, all are to be done. Beyond all these things, having filed the appeal also, if additional questions, additional issues are to be raised, it is again settled position. There, the tribunal again has the discretion to admit additional issues as well. These things are required, fundamentally to ensure that all issues which are identified, even if it is missed earlier, are duly taken care of in tribunal filings. It would be very essential that the proceedings before the tribunal, right at the stage of drafting of the appeal, is primarily taken care of, bringing out all facts, bringing out all documents. So this is essential with reference to filing. As regards pleading as to what could be taken as issues, what cannot be taken as issues, Mr. Pathsarathy will be addressing. So filing, to my mind, becomes essential that you bring in every facts, every issue, even if it is missed in the earlier proceedings. I would not like to take, in fact, Srinivasan has taken longer time. I would not like to squeeze the time of our next speaker and close at this stage. If anybody has any specific issue, possibly they can send it as mail. I'll respond. Thank you.
Thank you, Balaji, sir, for that absolute masterclass in the strategy. Your ability to dissect and order an original and map out the critical decision matrix between a tribunal appeal and a writ petition is invaluable. Viewing these disputes through your dual lens, combining decades of deep commercial understanding with high court litigation experience, gives our client an incredible strategic advantage. Thank you, sir. Now, to conclude our expert presentation with an elite look at the courtroom reality, it's my absolute honor to introduce our final speaker, Advocate Parthasarathi sir. Parthasarathi sir is a true titan in our field, bringing an extraordinary 48 years of professional experience to this panel. His brilliant career spans nearly 2 decades in the prestigious Indian Audit and Account Services, key leadership roles in the Ministry of Finance, and an assignment auditing the United Nations headquarters in New York. On the global stage, he was also instrumental in establishing the India's Anti-Dumping Directorate in 1994 and has also argued high-stakes WTO issues in Geneva, representing the Government of India. Having commanded over 500 cases across the tribunal, high courts, and supreme courts, he is uniquely equipped to share the ultimate masterclass on the court craft pleadings and hearings before the GSTAT. Over to you, sir.
Thank you, Harsh, for the introduction, and good evening to all of you. I will start with a caveat that whatever I'm going to talk about court craft or advocacy, etc., those are all purely experiences. I don't think there is anything right or wrong with what I'm going to say. It's just sharing some of my experiences. But before I come to that part of it, I was just listening to the very interesting points made by my other colleagues before me. I've just only reminded of the formation of the then Customs, Excise and Gold Control Appellate Tribunal in 1982 for the first time when it was formed and jurisdiction was granted for filing appeals, etc. The type of problems which we could have faced at that particular point of time. But we didn't have this problem of pre-deposit at that time because 1982, we didn't have an automatic pre-deposit. Every appeal will have to file a stay application. Stay application will be argued before the tribunal. They will decide whether you have to deposit or not deposit. And only in 2014, for the first time, the mandatory 7.5% and 10% pre-deposit came in the excise, customs and service tax side. And at that point of time, there were also some issues relating to whatever you are talking about transition, except in this case, the GST has already come into existence and there was no appellate tribunal. And unlike in CGAT, where before CGAT itself, there was an appellate procedure direct to High Court. But here, without the GSTAT, you cannot file any appeal at all. So you have to keep waiting or you have to approach the High Court, etc. Those are the types of problems which we are having. So I was just reminded the same issue had come up in 2014 when people argued that my order was passed before 6th of August 2014 when the new act came for 7.5% and 10%. So I need not have to pre-deposit. And as always, it went up to the Supreme Court. Delhi High Court also had decided. They all said on the date of filing, what is the law prevalent? That's what we'll have to look at, not with reference to the date of the order on which it was passed, etc. If you had filed the appeal on or after 6th of August 2014, the law prevalent then is 7.5%. The old law had already been superseded, so that is not even available to you. Therefore, you need to follow only the new law. So that is how they have held it. But now the interesting problem here is not with reference to only that particular aspect of it. You also have the other things of nothing being operational for a long time, and then you are because it was not operational, you could not file an appeal even though you had time to file the appeal, etc. So now when you are coming up, especially for the 110(25) penalty portion which was being pointed out, I could have filed the appeal long before 2025 if the GSTAT was operational. I could have done. Whereas because of the government action, it was not operational, and I had to wait for filing. And by that time, the new amendment had come. Why should I be penalized to pay pre-deposit? So some very interesting questions are coming up. And we are going to see these peripheral issues are going to be decided probably the first 1 or 2 years before, and of course, simultaneously also, substantial issues are likely to be taken up. So with this very broad introduction, because everything has a precedent somewhere, because of GSTAT, etc., we can always get some precedent for application into the GSTAT also. That's what I wanted to mention. Because we are talking about pleading and written submissions, etc., as far as the GSTAT is concerned, as I think all the three colleagues have pointed out, it is already the second appeal. It's already the second appeal. Therefore, all the facts which are required would all have already been taken care of, or if they have not been taken care of, you have a problem. So we'll have to see how that problem is to be addressed. But now we are only talking about the second appeal. So I am proceeding on the basis when we are replying to the show cause notice, we have taken care of bringing on record every single fact which helps to substantiate our case and to defeat the case of the department. That has to be very clearly addressed. Now, one thing which I have always found from experience is when you are drafting an appeal and you are doing it, it's always easier when you are drafting to gloss over issues which are uncomfortable for your part. So whatever is very strong, yes, it's no problem. Whatever is uncomfortable, you may not, you can write something in the appeal and do. But I would always suggest, I always look at, whenever I'm looking at the draft appeal, what are the various points in the impugned order which are against me? And for those which are against me, do I have a credible reply? And then have I ensured that those are submitted in the pleadings? Do I have to supplement my submission in order to overcome that objection by additional evidence? As Mr. Balaji also pointed out, most of the evidence should have been placed already on record, but there are always provisions for adding. Even in Supreme Court, I have filed application for filing additional evidence because of certain changed circumstances, and those have been allowed even in the Supreme Court. But we cannot rely on those. Are like exceptions. Like 98% of the cases, you will go on the basis of whatever is already on record. Only in 2 to 5% cases, because of specific circumstances, you might have to bring additional evidence, etc. Therefore, when you are coming before the tribunal, and as everybody pointed out, my experience is 10 to 15% or maximum 20% are the cases we always win with the department. 80% we lose because most of the time department does. Whereas the reverse is true when you come to the tribunal, 80-85% we win at the tribunal, only 10-15% the department wins at the tribunal. This should probably also be what we have to expect in the GSTAT. So GSTAT is actually a combination of GSTAT and the VAT Appellate Tribunal. Whenever you are going to have a state member, it is going to function more like the VAT type of thing, the thinking, etc., how it is done, we are able to see. Whereas when you have state member, it is more like the GSTAT, where you have member judicial or from the IRS, Central Excise and Customs Service, Tax Service, and the member judicials or any case common for any of that. So we'll also have to see how this tribunal is shaped. Therefore, it is very important at the beginning, whenever we are arguing the first probably 100 or 200 cases, let's say in Tamil Nadu, we should take the best efforts to ensure that a positive impact is made on the tribunal and you are able to get favorable decisions so that that momentum can be accelerated. Therefore, as far as the pleadings is concerned, as I've said, because show cause notice reply, first appellate authority, and now we are coming to second appellate authority, you should have taken care of almost every single fact which is required. But sometimes you have to look beyond whatever has been submitted. You can also have to think, because some points are technical, do I have to put an expert affidavit on record in order to support my case? Because if there is an expert affidavit on a technical matter, and if that is not properly rebutted by the lower officers, then the tribunal finds easy to give the relief. Even the High Court and Supreme Court said, no, there is an expert affidavit and you have not dealt with it, etc. Therefore, we have to go on the basis of whatever has been affidavit. So think also of something over and above whatever is on record. In some specific cases, do you require an expert affidavit also to be placed on record so that it makes your case very strong? So that's also something which you'll have to do. Now, generally, when you come to arguing the cases, now it has become more or less like 100% certain that you always make available a written submission to the court. That is because when you are writing an appeal, you write a lot of things. But when you're going to argue, you are going to argue very, very specific points. And the members also would ask specific questions. The other side also is going to rebut your particular point. Therefore, the written submission becomes very critical. And when you are going to challenge, let's say the GSTAT order for them, you might have to rely on these are the written submissions which I have made, whether those have been dealt with properly or not, or are there any errors in the way in which it has been taken up and dealt with, makes your case easier when you are going to the High Court or Supreme Court. Therefore, written submission is very, very critical. And please take care, written submission is not again a repetition of the appeal. It's a very, very concise, focused thing on, if I am going to appear tomorrow and argue this, is what are the few points which I am going to take and argue. Those are the what I will put in the written submission. The second important thing which is case law. Now, generally, there is a tendency to take a lot of case laws and put in, etc. But very, very important to determine what are the facts of the cases which you are relying on. Are the facts coming close to the facts of your particular case, and then take it? Because I have also seen from experience, sometimes people come up with the 50 case laws, 40 case laws, a compilation, etc. Even yesterday in the GSTAT, I had this experience. And when the DR started saying that, the member said, what is this lifting the corporate wheel on a classification, etc. It's therefore facts, even when you're talking about, let's say, on limitation, there are hundreds of cases on limitation. But which particular case comes close to the facts of your particular case, and do it. Otherwise, the whole thing could get sidetracked and you may now lose focus for the particular case. Therefore, a written submission should be very concise. Normally, nowadays, if I go to right from Supreme Court, I have seen, High Court, Delhi High Court also, I practiced quite a lot of Chennai. They say not more than 6 pages, not more than 10 pages. They are putting very strict guidelines for written submission. It should be very pointed. You are specific to the points, etc., which evidence you are going to put the paragraph numbers, etc., and do it, because that also helps you to argue the case. And that also acts a very good aid memoir for the members when they are writing the judgment, because most of them are these days not dictating the order in the court. I find almost like 90%. Earlier, I've seen 50-60% cases, order used to be immediately dictated, so you know what is happening. But now most of it is reserved, because tribunals are sitting till about 1 o'clock only. They reserve everything, go back and write. Therefore, we have to ensure that whatever we wanted to say has been dealt with in the order. Therefore, the written submission becomes very critical. Therefore, the first important point I would say in court craft and advocacy is to have a very, very brief and also pointed written submission along with the particular case laws, etc. And while the GST Act may be new and the law may be developing there, But there are a lot of parallels between the GSTAT, the GST law with reference to customs, service tax, and also the central excise law. So you can draw a lot of precedences from those judgments in order to cover our situation. Therefore, we'll have to look for cases under the CSTAT also to see how you will be able to do this. Similarly, also on the VAT tribunals. So on VAT tribunals also, you have a lot of decisions on that. So those cases are also to be important. So a fully prepared synopsis and written submission and a case law compilation is important. And even when you are preparing a case law compilation, I have always felt that the case law compilation should be not a continuous list of, let's say, 20 cases. It should be with reference to what is the proposition. For that proposition, what are the case laws you are relying on, and which court, Supreme Court, High Court, etc. And also write what is the relevant paragraph you are relying on. That is to ensure that you will also not lose focus. And when after the order is reserved, the tribunal goes and start writing, they'll say, okay, this person is about to para 18. What does para 18 say? He will look into it and he will be able to correlate that. So the case law compilation should be proposition-wise, the cases must be listed. Then within those cases, which specific paragraphs you are referring to in support of your case, that also must be marked so that it becomes very easy for the tribunal when they go back and write the order to refer to those particular paragraphs. That's also an important thing which you'll have to say. See this, for example, if we are talking about a case, we have to deposit 7.5%. We have to deposit 10%. Now, in this case, 10% plus 10%, etc. Now, for some reason, let us say in an appeal, an appellant is not able to deposit that 10% or 20%, etc. Both the tribunal or the first appellant, they cannot do anything where they are creatures of statute, as we call. So if you don't pre-deposit, they cannot admit the appeal. But there are also ways of challenging it before the High Court, because we always say Article 226 is an extraordinary remedy, writ remedy. Therefore, a pre-deposit which cannot be waived by the first appellate authority or the GSTAT may, in very rare cases, waived even by the High Court. And there are instances in Customs Central Excise where such waiver has been granted. And in fact, on 24 June, I am arguing one such case before the Supreme Court where I got a waiver from the Delhi High Court. And the department has challenged it, saying because of Section 129E of the Customs Act, the High Court cannot waive that 10%, etc. It's coming up before the Supreme Court. And it's very important to point out Article 226, they still, of course, they will not grant a waiver of pre-deposit in every case, but in rare cases and in where there is genuine hardship, etc. cost, they can grant. So that, of course, proposition is going to be tested before the Supreme Court on 24 June if the matter goes on. So there are instances under the Customs Excise Service Tax also where, because pre-deposit could not be made because of very, very extenuating circumstances, approached the High Court, got relief in some cases, not got relief in some cases, and one of them is now under challenge before the Supreme Court. You're going to see that. Therefore, every single aspect of the case we'll have to look at. There are always precedents somewhere which may be in our favor. So you have to look for those cases and see, of course, I always tell them, never take a case law and say, refer to para 16, say, a classification issue, extended period cannot be done. It is not like that. On classification, extended period, but you must always look to the facts of a particular case. So in a particular fact, it may show that you knew what was the correct classification, but yet you did not do the correct classification. There might be a penalty, there may be extended period, etc. Therefore, everything, according to me, the most critical point is facts. That is why even before the GSTAT, when you are coming up for an appeal, the most important thing to see is, have you done all the facts which are required before the previous authorities, so that you will be able to rely on them and win your case before the tribunal. Of course, I also have this habit. I always say, if I am going before a new judge or a new bench, 1 or 2 days before the case, I always go and sit in the court and watch how that particular judge is asking questions or how is he listening, etc., so that you can always gain an experience. So now we are going to have a tribunal with a new judicial member, new technical members, etc. So if it's better, probably before your case comes up, go sit there and observe how they are doing it, so that you can mold your strategy depending on particular. Because I have seen cases where the moment I start and I would have gone only 5 minutes, immediately the member, is that all, Mr. Parsad? Is that all, Mr. Because somebody is in a very hurry. The member wants to close the particular case. Therefore, you must also be prepared to show your case in 5-10 minutes and try to close. There are judges who said, take your own time and argue slowly. Every point you go about 10 years. So they have taken 6 hours, 8 hours also I have argued. So it all depends on that. Therefore, it's also one of the important things is, if you have not appeared before that particular judge, better to watch them 1 or 2 days before your case comes up to see how the particular judge is handling it, so that you can also mold your strategy according to that and take it. And also, you see, sometimes the member technical will take a lead, sometimes member judicial will take lead. So who takes lead, what types of questions they're asking will give you an idea into how their mind will work when you're coming to your particular case. That's also, according to me, very critical. And of course, needless to say, we have to get the decision favorable for our client from them. Therefore, we have to be polite, irrespective of any amount of irritation that the bench may cause. You cannot afford to lose your cool. So you have to be very, very polite and do it. Therefore, I think these are things which you learn, a lot of things you learn by experience. And I have always said to my colleagues here also, this profession, the last 30 years, 96, I've been on practice. So I always said, it gives me extraordinary amount of patience. And second is, it allows me to follow Bhagavad Gita, that all that I can do is to do my job properly, leave the rest to God, because the decision sometimes, cases which are 100% winnable, you don't know why they lose. And I have a lot of, butterflies in my stomach when I go, because I know the case is weak. I don't know why that case is won. So sometimes all that you can do is prepare well and make the best possible presentation. As somebody said, at the end of it, have you done everything in your power to bring it to the notice of the court? That's the question which I'll have to ask. Results, of course, are very, very material, but they are purely not in your hand. So that is the court craft which you'll also have to develop over a period of time. I think 7 o'clock is the time. I think I want to leave some time for questions on some of those earlier sessions. Also, you have a lot of things to be done. So I will stop at this point and I wish you all the best. And now open to questions, Harsh. You can go ahead and take over.
Thank you, Parthasarathy sir, for sharing your immense wealth of experience with us today. Hearing insights on the court craft and advocacy from someone who has commanded over 500 cases across the high courts and represented the country at the WTO is an absolute privilege. Thank you, sir. Now, ladies and gentlemen, we have covered a tremendous ground today, right from the foundational statutory rules and the deep litigative points to the high-level courtroom advocacy. Before we officially open the floor to the specific question in the Q&A session, I'm just going to share my screen and take a few minutes to quickly run you through the process of the GSTAT e-appeal filing process.
I think they have to process a lot of information. I think they have to have internalized a lot of information has come through today from all the speakers. I think they will have to probably do that.
Yes, sir. So I'll just not take much of a time, probably quickly within 5 or 10 minutes. I'll just give a short brief on how the e-filing process works on the GSTAT portal. So is my screen visible to everyone?
Yes, it's visible.
Yeah. Okay. So unlike the first level at the the first appellate authority, wherein we were filing the appeal applications in the GSTN portal, with respect to all the GSTAT appeals, there is a specific dedicated portal that has been there, and for each and every registration, you'll have to create a separate login in the GSTAT portal, wherein once you enter the GSTN number and you will give the basic OTP that is required from your registered mobile number, automatically a login will be created. And for each and every appeal that is being filed before the GSTAT, it has to be filed through that login only. And as far as the other processes are concerned, Now, that is one basic thing that has to be done, wherein for each and every registration where there is an appeal to be filed before the GSTAT, a separate login has to be created, and only through that login you will be able to file the appeals. Now, next question comes is, what about the scenarios where the order has been uploaded and where the order has not been uploaded? Now, in cases where the order has already been uploaded to the GST Common Portal, the GSTAT Appellate Portal and the GST Common Portal is basically interlinked. So thereby, once you enter the ARN number, the appeal ARN number, the GSTAT portal will automatically fetch all the data from the GST Common Portal, right from the details of the order till all the amounts that you have paid till the first level. In the electronic liability ledger, because the GSTAT portal and the GST Common Portal are interlinked. So all the details will basically be fetched from that particular portal, and thereby there is no need for you to worry as to whether these details have to be filled manually or not. Whereas there is one more concern wherein there are many cases where the orders have been issued manually. Now, in those cases, the right approach would be to now approach the appellate authority and request them to upload the order into the GST Common Portal, because once they do that particular exercise, automatically all the data will be fetched from the Common Portal. But however, there could be scenarios where the appellate authority may not, or for any other reasons, probably the order would not have been uploaded into the GST Common Portal. Then in these scenarios, you also have an option to file the appeal basis a manual order, wherein in the particular drop-down, wherein select filing through drop-down is there, you will have to select the option that ARN and CRN is not available. So in that case, the only pain point will be there that you will have to fill all the basic details of the order. Whereas this particular GSTAT appeal form, unlike the first appellate authority, wherein we file the appeal in a very smooth manner and not a lot of details are required. Whereas at the GSTAT level, there is a lot of details that are required. To specifically fill this particular GSTAT form itself will be roughly taking you about 1 to 1.5 hours for us to complete the entire information that has been required here. So thereby, in specific scenarios where your order has not been uploaded to the GSTAT portal, then in those scenarios, all the basic details which could have been directly linked or picked up from the GST Common Portal will now have to be filled by us, and then we'll be able to file the appeal. So thereby, just be mindful that even in case if you have a manual order and the same has not been uploaded, the due date still remains to be 30th of June, and we'll have to ensure that we file the appeal before 30th of June by selecting the manual option. Now, next, to bring upon the various aspects, there are various tabs, right from the basic details tab till the upload documents and the code tab that is there. Now, if you see, I'll just basically run you through the tabs in a very quick manner and not taking much of a time. So in the basic detail tabs, automatically all the details that have been mentioned here will be picked up from the GST Common Portal if your order is uploaded in the Common Portal. Now, in case the order is not uploaded, then all these details have to be manually filled, and including there is an option to upload the impugned order here. So those that impugned order, whatever you have received in manual form, has to be uploaded here. Once you fill the basic details, the next item will be to fill the case details. Now, this case details are not very simple as in the first level. There are various, fields, and a lot many data has been requested here. And if you specifically see here what the issue is relating to, there is basically a drop down wherein roughly about some 8 to 9 sort of drop downs have been given, wherein we'll have to select one particular drop down and of what the issue is pertaining to, and basis that what is the demand amount that is as per the adjudicating authority, and what is the stand before the what is the determination that has been made by the appellate authority or the revisional authority, and what is your stand before the tribunal. All these data has to be filled here, and wherein each and every field give you a limitation of roughly about 2000 characters. So within that 2000 characters, you'll have to summarize exactly what was your finding in your OIO, what was the finding in the OIA, and now what is your stand before the tribunal, and then what is the present pleading or whatever you are going to place before the tribunal. Those also has to be filled here. And separately, if you look over with respect to the constitution, if you see, there are various details that are required. It is not limited to only when the GST registration has been obtained. It is also extending to a part wherein you will have to give what is the constitution of the business, the statute under which this particular business was incorporated, what was the date of incorporation. For example, if it's a private limited company, then you'll have to give out the constitution, that is the Companies Act under which it has been registered. You will have to give the date of constitution. You'll also have to give the SIN number or whatever is the identification number that is there for the private limited company. Along with it, the address of the head office and the principal state, and any other facts which may be relevant to be in the view of the appellant, which the tribunal should know before adjudicating the case. So all these informations have to be filled across in the the case details. And as far as the appellant details and respondent and these details will be by default auto-loaded from the GST portal if it is there. And similarly, in case where there is not there, you'll have to fill these items manually. Now, one specific item is there in case of authorized representative. Each and every authorized representative, for example, if you're appointing an advocate or a chartered accountant, those persons have to be separately registered on the GST in GSTAT portal, wherein they'll have to create a separate login. And in the representative part, you'll have to specifically, there'll be a drop down wherein you'll have to select their name and appoint them as an authorized representative. So this is one additional feature which is there, which was unlikely not in the previous in the first appellate case and those kinds of scenario. And the one more thing is that in the authorized representatives login, once you select him as an authorized representative and file the appeal, automatically this particular case will be popping up in your AR's login as well, showing him the basic details. Now, next, to run you through the demand details. These demand details will be automatically fetched from the electronic liability ledger from the GST Common portal. Whatever pre-deposit that is required, all these discussions, whatever, or the deliberations that we have had in the past 2 hours, the pre-deposit has to be filled only in the GST Common portal. And in case if you have paid the pre-deposit through form GST DRC 03, then there is a new form that has been introduced, that is form GST DRC 03A, wherein you can link that particular DRC 03 to the electronic liability ledger or the demand liability ledger that has been created in the order through the form DRC 03A. Once you link the DRC 03 with the liability ledger, and the the GSTAT portal will automatically pick out all the data, wherein you'll only have to fill the specific information as to how much amount you are disputing based on the OIA, how much amount you are going to dispute, and what is the amount that you are going to admit and pay the amount. Once you pay the amount and adjust it there, then probably that'll solve the case. Now, next, once you pay, once the pre-deposit section is completed, the next comes is the court fee field, wherein you'll have to pay a court fee, which is ranging from a minimum of 5,000 rupees, subject to a maximum of 25,000 rupees. And for every lakh of dispute, 1,000 rupees court fee is required to be paid. So now this particular court fee, as on date, it is currently being auto-populated. So based on the demand details, automatically the court fee requirement, whatever is there, will be auto-populated. And this particular amount has to be paid only on the GSTAT portal. It need not be paid anywhere else. You'll automatically be given an option either to pay through net banking or through the Bharat Kosh facility is there. Probably through that mode, you'll have to make the payment of the court fee amount. Now, earlier we were also facing certain issues with respect to the court fee, wherein the court fee was being computed erroneously, or probably there was some issues with the calculations. But with the recent the GSTAT has there has been a communication that these issues have already been resolved. Probably we'll have to see how the automatic loading and all those functions of the court fee are working. Now, next, to move on, once you fill all these details, then there is one specific tab wherein you'll have to upload the documents. Now, unlike the first level, wherein we used to upload certain documents and the entire set of the appeal documents used to be submitted before the appellate authority. In the GSTAT, in the GST Common portal itself, there was an instruction which used to say that only a maximum of 4 annexures can be uploaded, and any annexure beyond the 4 annexures can be submitted in manual form before the first appellate authority. However, the GSTAT with the basic interactions, whatever we had, the GSTAT is totally aimed to be paperless, wherein they're not going to accept any physical records, and whatever submissions that we are required to be made, all those submissions are to be made on the GSTAT portal itself. And there is an extensive documentation requirement that has been put down here, wherein a set of individual documents along with the consolidated documents to be on the safer side has to be uploaded here. And there is also one specific requirement that the document has to be, each and every PDF has to be bookmarked, and at the same time, one PDF should not have more than 100 pages. Now, to specifically, for relaxing this relaxation, since there is a lot of documentary, this thing has to be uploaded, the GSTAT has basically issued an instruction wherein they have told that till the 31st of December, for the ease of filing, in case if you wish to file an appeal before the tribunal, if these 5 items are there, they'll be, they have requested the registrar not to raise any defects. Those 5 basic documents are: one is your order in original, your order in appeal, your show cause notice, statement of facts, grounds of appeals, and the pre-deposit and the court fee acknowledgement for the payment of the pre-deposit and the court fee. All these things have to be uploaded. The order in original, order in appeal, and the show cause notice, it has to be self-certified by you. And if you upload these items, the registry has been instructed not to raise any defects and to allow the appeal to be admitted before the GSTAT till the 31st of December. Post the 31st of December also, if you see, if you see the upload document requirement, there are roughly about these many documents have to be uploaded. Earlier in this upload document portal also, there was one specific issue wherein the affidavits were being made mandatory. Unless and until you upload the affidavit into the GSTAT portal, it would not allow you to proceed further. But however, that particular defect has now been resolved. Now you can file the appeal even without uploading the affidavits. Now, in case an affidavit is being enclosed along with the appeal certifying, then it has to be notarized and all those other requirements as per the GSTAT rules has to be followed. So now with the instructions being extended with the basic 5 documents, once you upload that and you will be able to go ahead and file the appeal. Now, any issues or any queries with respect to the e-filing process and the session that we have gone through in the past 2 hours, you can put it through your chat box, or probably you can raise your hands so that we may take your questions.
I have to thank you, Harsh, again for speedily taking through the entire e-filing. So I think all of us picked up some points from that one. So
Yeah. So Harsh, you can also share the email ID, because considering the time, we are already past 7, like 14 minutes. You can share the email ID as well. Whatever queries that the participants may have,
Sure, sir.
they can as well share it over email.
Sure, sir. I'll just put down our emails in the chat box.
So queries, we can take it over email. You can probably wind up the session.
Sure, sir. So probably I'll just end the session with a vote of thanks. So as we bring this highly insightful session to a close, I would like to extend a formal vote of thanks. First, a sincere thanks to all our esteemed panel of experts for taking their time to decode the complexities of the GSTAT. Your practical guidance on everything, right from the e-filing and the procedure and the statutory framework to the advanced courtroom advocacy, has been invaluable. Most importantly, thank you to all the participants for joining us today. At Shreyas, our primary objective is to maximize your organization's wealth and to solve the problems at the source. We hope that the clarity brought to you today empowers your team to handle the future legal disputes and the regulatory challenges with complete confidence. Thank you all for your time and have a wonderful evening ahead. I'll just put down the emails in the chat box. Any queries or anything with regard to the today's sessions can be sent down to the email. We'll be getting back to you shortly.
Thank you so much.